Hello, this is R.J. Deacon reading the Supreme Court of the United States opinion syllabus in Sanchez v. Mayorkas, Secretary of Homeland Security. Certiorari to United States Court of Appeals for the Third Circuit. Argued April 19th, 2021. Decided June 7th, 2021. If you'd like to support the podcast, please stay tuned to the end of the podcast. Petitioner Jose Santos Sanchez is a citizen of El Salvador who challenges the denial of his application to become a lawful permanent resident, LPR, of the United States. Sanchez entered the United States unlawfully in 1997. In 2001, the government granted him Temporary Protected Status, TPS. The TPS program allows foreign nationals of a country designated by the government as having unusually bad or dangerous conditions to live and work in the United States while the conditions last. See Section 1254A. In 2014, Sanchez applied under Section 1255 of the immigration laws to obtain LPR status. Section 1255 provides a way for non-immigrant, a foreign national lawfully present in this country on a temporary basis, to obtain an adjustment of status to LPR. That's 8 U.S.C. Section 1255. The United States Citizenship and Immigration Services determined Sanchez ineligible for LPR status because he entered the United States unlawfully. Sanchez successfully challenged that decision before the district court, which reasoned that Sanchez's TPS required treating him as if he had been lawfully admitted to the country for purposes of his LPR application. The Third Circuit reversed, finding Sanchez's unlawful entry into the country precluded his eligibility for LPR status under Section 1255, notwithstanding his TPS. Supreme Court held decision is affirmed. Justice Kagan delivered the opinion of the unanimous court. A TPS recipient who entered the United States unlawfully is not eligible under Section 1255 for LPR status merely by dint of his TPS. Section 1255 provides that eligibility for LPR status generally requires an admission into the country, defined to mean the lawful entry of the alien into the United States after inspection and authorization by an immigration officer. Section 1101A.13 Cap A. Sanchez did not enter lawfully, and his TPS does not eliminate the effect of that unlawful entry. Section 1254A F4 provides that a TPS recipient who applies for permanent residency will be treated as having non-immigrant status, the status traditionally and generally needed to invoke the LPR process under Section 1255. But that provision does not aid the TPS recipient in meeting Section 1255's separate admission requirement. Lawful status and admission are distinct concepts in immigration law, and establishing the former does not establish the latter. Sanchez resists this conclusion, arguing that the statute's directive that a TPS recipient shall be considered as a non-immigrant for purposes of Section 1255 means he must also be considered as admitted. But the immigration laws nowhere state that admission is a prerequisite of non-immigrant status. So, there is no reason to interpret the TPS's provision conferral of non-immigrant status as including a conferral of admission. In fact, contrary to Sanchez's position, there are immigration categories in which individuals have non-immigrant status without admission. See, for example, Sections 1101A10, 1101A15U, 1182D14. Thus, when Congress confers non-immigrant status for purposes of Section 1255, but says nothing about admission, the court has no basis for ruling an unlawful entrant eligible to become an LPR. The decision below is affirmed. Justice Kagan delivered the opinion for a unanimous court. Thank you for listening. If you'd like to support the podcast or support me as I try to get to my public defender internship this summer, you can find a PayPal link in the show notes, find me on Patreon, or contact me at rhodesscholar80@gmail.com. That's ROADS and the number 80.